The next concept is remoteness of damage. What is damage? Damage means loss or injury that you have sustained, right? If you have
person or property, right?
To person or property. It can be property, so it can be person, your reputation, whatsoever damage you have sustained. What is remoteness of damage?
That day we talked in that contract that suppose one in a railway station, one family was made to get down in some different station, so they had to walk to some other station, and during that walk the wife suffered some cold, she got wet in the rain, she got cold and all. So for that is a remote damage that cannot be claimed.
Yes.
The inconvenience for dropping them at a different station, that can be claimed.
Yeah.
So indirect, basically indirect cause.
Yeah, indirect cause, right? Or remote, like we use remote to operate TV from a distance. From a distance, something has happened, but there are many other contributing factors also. That is remote damage. Now, in case of tort, the basic difference between tort and contract is that in contract, we are mostly fixing the amount that needs to be paid, right? We decide an amount, but in case of tort, we cannot do that, right? If someone enters my premises without my permission and commits the wrong of trespass, I do not know what may be the amount of loss that I may suffer, right? Just a normal individual, the person simply entered my premises and he left. I have not sustained any injury as such, but court may give me some amount of compensation that, okay, fine, take this 6,000 rupees because your right is being violated. All right. In another case, there may be a very big company who is having multiple clients, and clients have shared some confidential information with them on the assurance that company will maintain high security there. No stranger can just come and enter there. But if a person enters the company without their permission, without approval, basically trespass, their clients may lose faith on the company and they may just leave the company. In that case, maybe the company has sustained lakhs of loss, right? Lakhs of rupees of loss. So we cannot just define, okay, this is the amount of loss that we will be suffering. That is why it's always unliquidated damage. That means it's not prefixed. Only when the situation will happen, you go to court, court will decide how much you need to pay, how much amount of compensation you need to pay, right? So remoteness of damage here also, basically it will mean how remotely it is related, right? It should be very like a proximate cause. Because of
proximate,
proximate, right? Because of my wrong only you have sustained the injury. It should be like that. Otherwise, I will not be made liable. Right? If take for example, you are complaining that I am playing loud music every single night. It has that reason only which is affecting your sleep, which is disturbing peaceful residence or other things, right? It should not be that you are also using some mixer grinder at night and that is like some family member of yours is using mixer grinder, as a result also you are getting up in the middle of the night. There are some other factors also. It should not be like that, right? It has to be directly me only because of which you are suffering that problem or that issue, right? I think you remember it from contract classes also. Remoteness of damage. It should be directly related accordingly. Now, in case of torts, we have different types of remedies that are being given. Remedies as in some relief that court will give, right? That, okay, fine, you have suffered loss, you have suffered enough. Now take this relief and stay happy. All right, so there are different types of reliefs that court may provide. Some are called as judicial remedies. Some are called extrajudicial remedies.
Extrajudicial, yeah.
What is judicial? Very much understood from the word that
according to law.
Court. Yeah, according to law, and you get from court, right? You will go to court, court will provide you damages, court will pass an injunction order. All right, those are judicial remedies, or it may be specific restitution of property. Extrajudicial as in you are taking law in your own hands. Okay, now examples of tort can be what? It can be nuisance, it can be some sort of negligence or certain things, right? Take for example, I park my two-wheeler in front of your gate. As a result, you cannot take out your car. What will you do? Will you go to wait for me to remove my two-wheeler, or will you go to court, file a case against me? You will not do that. You will simply remove the two-wheeler, right? You will keep it aside and you will take out your car and you will leave, right? It's called as extrajudicial remedies. That if something is disturbing you, you will remove that object and go carry forward with life, right? That is extrajudicial remedy. You are not taking help of law, you are simply doing the thing yourself. All right. If take for example, you are sitting at your home, someone is trying to enter your house, they opened your gate or something, like a stranger, what will you do? Will you wait for that person to come inside your house, commit a tort, and then go to court, file a case? You will not do that. You will simply tell the person that, ask the person to leave, right? That's also an extrajudicial remedy, that you are simply doing whatever best you can do, right? Those are different types of remedies that we have available under law of torts. So you can take help of these things also. Like if there is damages will be paid only when it is like a proximate thing, otherwise not. If damages are not sufficient, sometimes injunction order may also be passed. Injunction means court will ask a person to do or not to do something, right? Accordingly, you can write these things. Remoteness of damage. As for remoteness of damage, if a question is there, you can give illustrations on the basis of damages, injunction, etc. And you can write that it should be like a direct and proximate cause of it only.
Yeah. My own example also I'll make and give, like of a case.
Which case?
No, for a case, if I can't remember my own example, I can make.
Yeah, you can get, or if you know for sure, okay, take for example that Rollins versus Fletcher, you remembered the facts very well, but you forgot the case name. In that case, you can, rather than write as illustration, you can write in a decided case. Okay, that's also a good way. If you do not remember the case, you can just remember in a decided case, this happened. Or if you are not sure whether it was a case or an illustration, you have doubt, in such cases, you make it an illustration. You put just for an example, this happened, that happened. If you remember it's clearly a case, you simply write in a decided case and then go ahead with whatever you remember.